What's up, guys? It's your boy Jay-Z, and today we're doing something slightly different from the usual gaming videos because we're going to be talking about qualified immunity. Now, this is due to the killing of George Floyd and others who have died at the hands of law enforcement in America, i.e., Breonna Taylor, for example. There have been a wave of renewed calls for those guilty to be charged and prosecuted. However, due to the failures of the past to secure justice, the public appear unwavering in its conviction that proper change occurs rather than simple lip service. As a result of this wave, I was motivated to look into why it seemed that police get away with crimes of brutality, during which I came across a possible explanation which gave police the excuse that they can shoot first and think later. The answer to which is cleverly used as a title to the video, i.e. qualified immunity. Thumbs up for that title though. But before I start, I feel that it's responsible for me to have a quick disclaimer that although I studied law in America for 1 year during my year abroad, by no means am I an expert in American law. However, I did graduate with a 2-1 from university studying law, which means I have some legal knowledge, but I'm still a relative novice. Hopefully, having explained that, you will not take my word as gospel. But in fact, I hope this video motivates you to investigate the area for yourselves. I'm gonna make a small list of websites that I use to research this topic available to you in the description below, so that you yourself have a good starting place to further your own research into this area. So I hope we're all good. Yep. Awesome. I'm gonna take your silence as confirmation I can continue. Qualified immunity. Not many people really know what that is or what it means. But to those of you who do know what it means, well done, because if you was to ask me prior to George Floyd's death, my face would look like someone who was just told that Xbox is better than PlayStation, which FYI is not even close. There's no way on any earth or any planet that you can say Xbox is better than PlayStation. Misremove all that stuff. The defense of qualified immunity was first introduced by the Supreme Court in 1967 in the case of Pearson v. Ray. The reason for its inception was to protect government employees from lawsuits brought by the public, and so give police breathing room to carry out their jobs without fear of repercussion. The test to decide whether qualified immunity is granted is based on a two-part question, with both requiring the answer to be yes for the defense to be removed, whilst the no ensures the defense is available. Part 1 asks whether evidence shows or could convince a jury that the officers used excessive force in violation of the Fourth Amendment. If the answer is yes, then the court moves to Part 2 of the test. If no, qualified immunity is granted. Part 2 asks whether the officers should have known they were breaking clearly established law. If the answer is no, qualified immunity is granted. If the answer is yes, the case goes to trial without the defense. Clearly established law, for those who don't know, explained simply means if in a previous court decision a case containing a set of facts were decided one way, judges hearing cases afterwards which are similar to the previous case will take it into consideration as an example or guide when basing their decision on the current one. Now, I will not be surprised if some of you people were probably thinking, cool, I understand all that, but how does this stop police from being charged? Surely, if their actions were so bad, they would be in prison. Well, in response to this, I will direct you to the Reuters site who wrote about the death of Johnny Leahy. I believe once you read his story, you'll begin to understand the barrier to justice qualified immunity can create. And if you still don't see a problem, I want to really urge you to continue reading or listening to my evaluation, as hopefully I will ease some of the confusion you may be having. So on the 24th of March, Mr. Leahy was in a local hospital because he had been sick and disorientated due to his pneumonia. The staff at the local hospital called the police for help, giving Mr. Leahy an injection to calm him down. The events which take place when the police arrive are shown briefly on the Reuters website, as it was caught by security cameras in the hospital. Regardless of whether you access the website or not, I'm going to give a summary of what the cameras show for those who are unable to access the website at the current time. What the cameras show is a video of Mr. Leahy walking along a hallway, being followed by 3 police officers. Afterwards, a struggle appears to unfold where he's somehow wrestled to the floor, and after which he kinda goes limp. You see the hospital staff try to resuscitate him, but unfortunately they are unable to do so. Mr. Leahy's death was said to have been caused by his lungs, which were already weakened by his pneumonia, being starved of oxygen during the struggle he had with the police. Now, as you'd expect, Mr. Leahy's mother attempted to sue police following the death of her son, alleging that the officers had used excessive force. Unfortunately, her case fell due to the defense of qualified immunity, despite her lawyer arguing that the police officers' treatment of Mr. Leahy was clearly established as legal. To argue his point, the lawyer pointed to previous cases in which police were held liable for using excessive force on unarmed, mentally compromised people. However, the court found that these cases were not similar enough to the present circumstances, thus the police had no reason to think they were breaking the law and so had the defense of qualified immunity. A major problem with this defense, and therefore potentially cases involving it, is that it is highly unlikely that a case is going to be 100% identical to another one. This means if we literally follow the line of reasoning to a logical conclusion, the cases must be nearly identical in order to be considered. Therefore, it is almost impossible for an officer to be held accountable if they are the first to misbehave in a certain way. Hence, when the court draws such a strict line on what counts as clearly established law, it can create confusion and potentially a lack of justice in future cases. One such example was actually raised in the Wall Street Journal by Robert Nakamura, sorry I'm probably butchering his name, in the case of Cezanne West. In this case, an Idaho woman gave her house keys to the police to search for her ex-boyfriend who was wanted by them on firearm charges. Though he was not inside, the police threw grenades and fired shotguns at the house until it was uninhabitable, leaving her homeless. Unsurprisingly, Miss West sued the officers for violating her Fourth Amendment rights, but her claim was unfortunately rejected due to defense of qualified immunity. Mr. Nakamura's opinion as to the findings of this case further highlights the problematic rulings which can stem from the defense of qualified immunity. He points out that nobody seriously believes that consent to enter a home is permission to lob grenades into it. But no court has ever decided the question, because as far as I can tell, this is the first time anybody has made that argument. He goes on to say, since no court has considered it, qualified immunity means Miss West loses. As long as an officer's conduct is uniquely outrageous, it's impossible to hold him liable for it. To make matters worse, on top of what Mr. Nakamura had said, the case of Pearson v. Callahan, set in 2009, makes it harder to convict officers as the Supreme Court allowed appellate courts to skip part 1 of the qualified immunity test and so focus on whether the conduct was clearly established as unlawful. Therefore, in such cases, where the court does not establish whether police used excessive force in violation of the Fourth Amendment, it prevents setting a clearly established law for future cases as required by the second part of the test. In effect, this means the same conduct can repeatedly go unpunished as it creates a closed loop in which case law remains frozen and cannot move forward. This therefore eliminates the amount of cases the public can use to show that the actions of the police were illegal. From the research that I have done, I have gathered the following are the main justifications for qualified immunity. One is that it protects law enforcement officers being bankrupt by civil lawsuits. Though on paper this seems nice as police officers are not paid as much as they deserve, nobody's arguing that, and much like the NHS staff are not paid as much as they deserve. Justification ignores the reality that such costs are most likely paid by the officer's insurance or union. Moreover, even if they were getting sued, potentially it would make the police as an institution change their training or how they approach the public due to the economic repercussions it would have on the police as a whole if they continued having to pay fines for police brutality. A second justification that I have found is that without qualified immunity, law enforcement will be deterred from doing their jobs effectively. However, this in itself can be argued against, as law enforcement officers probably do not think about the threat of being sued when performing their duties, as it will hinder their ability to act in a split second, which would potentially risk their lives, their colleagues' lives, and the lives of the public. Just taking this into account, I think there's a strong argument to be made that the defense of qualified immunity should be removed, or at the very least changed, so that the public are more able to bring claims against the police. Critics of qualified immunity range from civil rights groups, lawyers, Supreme Court judges, etc. In dissent to the 2018 case of Kaiser v. Hughes, the justices threw out a lower court ruling that denied immunity to an Arizona cop who shot a mentally ill woman 4 times while she walked along her driveway holding a knife, in which Justice Sotomayor, sorry if I'm butchering her name again, along with a fellow Justice, Ruth Bader Ginsburg, wrote that the majority decision favouring the police tells them that they can shoot first and think later, and it tells the public that unreasonable conduct will go unpunished. Overall, given the wide array of criticism aimed at qualified immunity, as well as the inability for the victims of police crimes to obtain effective justice, there needs to be a closer look into the practical workings of the defence. Whilst I am wary to argue that the defence should be terminated, I do believe at the very least it needs to be changed drastically so that it not only protects officers when it is reasonable to do so, but also allows access to justice for victims of police wrongdoings. As previously mentioned, although people may point to the lack of protection it potentially affords to officers, denial of immunity does not automatically mean police will be held liable for alleged excessive force. I mean, when such cases go to jury trials, the juries may honestly side with the police after weighing the facts of the case, meaning the officer in question will hopefully only get punished if they are truly deserving of it, not because they are left without the protection of qualified immunity. Moreover, even if the officer is charged and ordered to pay, the insurers or the police institution themselves, not the individual officers, are the ones more likely to shoulder the financial burden of litigation, settlements, or jury awards. Finally, though people may point to infamous cases such as Eric Garner, Michael Brown, Tamir Rice, etc., to suggest that officers get punished, I remind you that in fact no criminal charges were given out in these cases, rather massive financial settlements. Arguably, this is because qualified immunity is probably not going to come into play in such high-profile cases due to the police coming under heavy pressure from both public protest and political condemnation. A potential reason for this being that rather than go through the court process, which is not only longer, but ensures more eyes and scrutiny will be applied to the police, a settlement may either bring the negativity to a halt or at least minimize it in order to give the police time to rebuild positive public sentiment towards them in the community. Now, do I believe that rule change may stem from this? I think looking at it optimistically, you could argue major brands have never before taken such political stances. However, looking at it pessimistically, it can easily be argued that they're only doing so because they're trying to appeal to what is seen as the majority social movement at the current time. Moreover, we believe other social changes have happened due to previous killings, but that wasn't really the case. I think the most important thing we need to look at is that I fear the voices of movement is getting lost in arguments about cancelling programs or statutes or removing phrases such as master bedroom. And I don't think that is necessarily what the majority of the people in the movement are asking for, but rather real change. So I think that's the end of really my views when it comes to why police struggle to get charged when it comes to crimes of police brutality. Hopefully you guys have found it informative. Like I said, I'm going to leave a whole heap of resources in the description box so you guys can look into it as a place for you to start your own research into this area if you find it interesting. I think if rule change is going to happen in America when it comes to police being charged, I do think qualified immunity does need to be looked into, and I think I'm going to be keeping a close eye on this area, and if anything major happens, whether it be removed or the government outright say they're not going to remove it, I'll probably make a follow-up video to this. But till now, I hope you guys enjoyed it. I mean, put in the comment section what you think of this area, and if you agree or disagree with me, I'll be interested to hear your thoughts. But obviously keep it civil and watch this space for hopefully more interesting videos. It's been your boy G-Eazy, and I'll catch you later. Peace.